In Module 2.1, we discussed the new inactive license status and the clear boundary between holding a license and being authorized to act. In Module 2.2, we examined renewal timing, electronic filing, and administrative severance. In Module 2.3, we explored disclosure requirements, certified records, and ownership transparency. Now we close Chapter 2 with the question every licensee hopes never to face. What actually happens if you fail to comply? Because clarity in rules does not only protect compliant agents, it also creates defined consequences for non-compliance. And in the post-2025 environment, those consequences are more structured and predictable than ever. Denial versus administrative closure. Let's begin with an important distinction that many agents misunderstand. Denial and administrative closure are not the same thing. An administrative closure generally occurs when an application is incomplete and the applicant fails to cure deficiencies within the required time frame. Think of this as a processing outcome, not necessarily a disciplinary judgment. For example, you submit a renewal application but fail to provide certified court documents requested under R4-28-301. The department sends a deficiency notice. You ignore it. The file may be administratively closed. Closure does not automatically mean your license is revoked. It means the application was not completed properly. Now contrast that with denial. Denial occurs when the department determines that an applicant does not meet statutory or regulatory qualifications. This may be due to failure to meet eligibility standards, material misrepresentation, failure to disclose required information, disqualifying criminal history, prior disciplinary issues. Denial is a substantive determination. It carries weight and may trigger reporting or additional review consequences. Here is where Chapter 1 becomes relevant again. Because rules are clearer, the department can more easily distinguish between incomplete processing and substantive disqualification. That predictability cuts both ways. If you forget paperwork, the issue may be administrative closure. If you conceal information or fail eligibility standards, the issue may be denial. Intent matters. Documentation matters. Timing matters. Substantive review suspension. Now let's discuss a concept that many agents experience without fully understanding. Substantive review. When you answer yes to certain disclosure questions, your application may move out of administrative processing and into substantive review. Substantive review means the department must evaluate eligibility based on statutory standards. During this review, activation or renewal may be delayed. In some cases, if a license is already active and a significant issue arises, the department may take steps consistent with its authority under Title 32. The key idea here is this: not every delay is disciplinary. Some delays are investigative or evaluative, but clarity in the rule structure allows the department to process applications more systematically. Imagine this scenario. You renew on time. You disclose a recent misdemeanor conviction. The department requests certified records. Your status may remain pending until review is completed. If you assumed you were automatically active and began practicing without confirmation, you may inadvertently create a separate compliance issue. This ties directly back to Module 2.2. Status must be verified, not assumed. Electronic filing makes timing clearer. Substantive review creates defined pauses in activation. The system now communicates status more transparently, and transparency reduces excuses. Right to appeal clarified. Now let's discuss due process. Arizona administrative law provides applicants and licensees the right to contest certain decisions. If your application is denied, or if discipline is imposed under ARS, paragraph 32-2153, you generally have the right to request a hearing through the administrative process. This may involve notice of the proposed action, opportunity to request a hearing, administrative law judge review, final agency decision, potential judicial review. The modernization clarified procedural language around notice and processing. Why is this important? Because enforcement authority must operate within due process protections. The department has power, but it must follow procedure. As a licensee, you have responsibilities, but you also have rights. Let's walk through a practical example. An applicant fails to disclose prior discipline from another state. The department discovers it and issues a notice of intent to deny. The applicant has the right to request a hearing and present evidence. That hearing does not erase the underlying obligation to disclose, but it provides a structured opportunity to respond. This balance between authority and due process is foundational to administrative law. Clarity in procedure protects both the public and the licensee. The bigger picture: risk and responsibility. Let's zoom out. Chapter 2 has focused on licensure mechanics: status, renewal, disclosure, documentation, ownership, and consequences. These may seem procedural, but they form the backbone of lawful practice. You cannot advertise legally, Article 5, receive compensation, Article 7, negotiate contracts, Article 11, handle documents, Article 8, unless your license is valid, active, and properly processed under Article 3. That is why Chapter 2 matters so much. Licensure is not passive. It is an ongoing compliance relationship between you and the department. And after the 2025 overhaul, that relationship is clearer, more digital, more structured, and more enforceable. A memorable rule of thumb: if you remember nothing else from this chapter, remember this: assumption creates risk, verification creates protection. Assume your renewal went through, risk. Verify your status online, protection. Assume severance timing doesn't matter, risk. Confirm broker affiliation before acting, protection. Assume old history doesn't need disclosure, risk. Disclose and document properly, protection. The rules are clearer now. That clarity protects agents who pay attention. How this prepares you for Chapter 3. Chapter 3 will shift from licensure mechanics to advertising modernization. Now that you understand that your authority to act depends entirely on proper licensure, we will examine how your marketing conduct can independently create disciplinary exposure. Licensure gives you permission. Advertising tests your judgment. And in the 2025 regulatory environment, both are under clearer scrutiny than ever before.